A therapeutic boarding school in Utah told a vomiting team to suck it up before the infection that was causing her to throw up killed her from sepsis. So the boarding school looked at this sick vomiting teen, said, suck it up, but actually sepsis. So great. Good job. Good job handling that situation. All right. The 17-year-old girl died last December at a school for troubled teens in Utah after experiencing extreme pain for a treatable infection, according to the autopsy. The revelation that Taylor Goodridge had the disease shows that the daughter's death was entirely preventable and would be alive today if she had retreatment that she had begged for at the time. So apparently, this girl had been sick for quite some time, and the school appeared to not care. And so, yeah. The autopsy's result emerged as parents continue their lawsuit against Diamond Ranch Academy on claims of false imprisonment, premise liability, innkeeper liability, child abuse, negligence, and reckless indifference, and breach of fiduciary duty. All those things sound plausible. In the complaint filed in 2022, Taylor Goodridge was identified as Washington State resident staying at the boarding school in Utah. Diamond Ranch Academy filed a motion to dismiss just a month after the plaintiff filed. Family amended the complaint to add John Doe as the defendant. A proposed second amended complaint specifies that John Doe defendant is Big Springs Property, the owner of the property, which makes sense. Sue the school, sue the landowner, sue everyone in sight is typically how you do this, right? Diamond Ranch Academy promises parents that students will be able to ensure their basic health needs, such as requesting appointments, addressing medical concerns, and medical staff would tender their needs on site as if they were family medical practice. Given these representations, the plaintiff's minor daughter was matriculated into the program, removed from her home, and physically placed in the program where she was a resident for several months. Unbeknownst to plaintiffs, and despite the assurances, representations, and promises, children that become ill are often ignored or told that they're faking their illnesses. Many claim they're given aspirin and water and told to suck it up. So, yeah. If you are a guardian, in fact, for a child, right, like at a school, like a boarding school, that gives you certain positive obligations, unsurprisingly. So if you are caring for a child, 17-year-old or not, telling them to suck it up, if that's part of a pattern of conduct and part of a general pattern of showing active disregard, you're going to have a problem. So Academy over here looking like things are going not great. Litigation says that Taylor herself was specifically told, suck it up. The plaintiffs allege that their volleyball athlete and cheerleading daughter began to experience pain in December. On December 6th, Taylor's scheduled Zoom call with her parents was canceled based upon behavioral issues. A week later, Taylor was vomiting, and this apparently continued for days. So, yeah, I would think at some point you would be a little bit more concerned about it. The pain apparently became so excruciating that Taylor was begging the staff for help. At one time, Taylor collapsed into her own vomit. So, things are going great over here at the Diamond Academy. The day that Taylor died, she allegedly was forced to shower and go to breakfast rather than be given emergency medical attention. The school called the father and told him that Taylor had suffered a heart attack. The school then called the father and told him that she had perished in the hospital from the heart attack. Yeah. The plaintiffs claimed Diamond Ranch Academy false imprisonment directly led to severe physical pain, discomfort, loss of enjoyment of life, and death. The U.S. magistrate judge ordered the second amended complaint filed within 14 days. Defendant's motion to dismiss, this should be good, argued that the plaintiff complaint lacked subject matter jurisdiction. Oh, okay. And multiple alleged counts failed to stay at claim. Particularly, defendants say the lawsuit improperly commenced before plaintiffs filed claims under Utah Health Care Malpractice Act to a non-binding pre-litigation hearing through the Division of Professional Licensing. What? I don't know anything about Utah specific law, but that sounds like some bullshit. But okay, maybe there's some sort of process they have to go through other than suing. All right. Goodridge has yet to participate in this non-binding pre-litigation hearing. If it's non-binding, why does it matter? And thus, the court presently lacks subject matter. Accordingly, they should dismiss, or on the alternative, stay until they've completed the pre-litigation. It's non-binding. So what does it matter? It's just a formality for the sake of formality at this point, right? It's like it doesn't matter what happens because it's non-binding. It's like I'm just going to go to lawsuit anyway. The underlying facts giving rise to the claim clearly demonstrate the subject litigation is wrongful death arising from medical malpractice. No, I don't think that's really necessarily the underlying claim. I'm not sure the underlying claim is medical malpractice. That's definitely one way to phrase it, but medical malpractice, not necessarily. The school isn't a doctor or a hospital. The owner of the property isn't a doctor or a hospital. Some of them might be nurses, but that it's medical malpractice, I don't, that's not inherently obvious. Despite this, they've creatively asserted multiple causes of action that are not cognizable or do not appear to apply to the facts. Okay. The aforementioned Second Amendment complaint noted that plaintiffs are in fact in the process of complying with Utah Code in order to bring in action pursuant to the Malpractice Act, and the complaint will be amended once that process is complete with. Plaintiff responded, this is not so much a medical malpractice case. Yeah, I don't really, yeah, but a case where there's no medical aid rendered at all. And also some of these people are not doctors, presumably. And so medical malpractice doesn't seem like necessarily the correct cause of action here. So, all right. The Utah Department of Health has noted the institution currently has a conditional license, meaning the provider is at risk of losing their license because it has not complied with licensing rules. Apparently, the provider was out of compliance by failing to provide and seek necessary medical care for an ill client. During on and off inspections, investigators concluded multiple interviews and reviewed program documentation. This information substantiated the provider was aware the client was ill and did not take them to an emergency room. So the Utah Department of Public Health seems to think that there was some deficiencies along the way as well. Yeah. Thus, that brings us to the end of the story of Taylor Goodridge, unfortunately, who died as a result of apparently massive neglect because she was apparently sick, ill, and vomiting for days and did not get medical care from the people that were in charge of her guardians, in fact, who, as you would expect, have some obligations to her in that role. The family sued, and apparently they have to comply with some non-binding blah, blah, whatever. So they're in the process of trying to figure that out. And I think that in the end, if all this is proven, I think the school is in a fair amount of trouble. And that, for the moment, brings us to the end of the discussion of this story.